In 1816, Congress established a second national bank to control the amount of unregulated currency issued by the state banks. Private stockholders controlled the bank, however, it was the depository of federal funds. In addition, it had the authority to issue notes that, along with the notes of the state banks, circulated as a legal tender. The bank agreed to loan the federal government money in lieu of taxes. Many states questioned the constitutionality of the bank. Maryland did not believe in the bank, thus they imposed a tax on any bank not chartered in the state. When the Baltimore branch refused to pay the tax, the court sued James McCulloch, cashier of the Baltimore branch of the bank, for collection of debt. Eventually, the case was appealed up to the Supreme Court.
Now in session debating James McCulloch versus the state of Maryland. The Supreme Court of the United States hereby calls Daniel Webster, a representation for James McCulloch, a cashier at the Baltimore branch of the Second National Bank.
Present, Your Honor.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Do, Your Honor.
The case of James McCulloch versus the state of Maryland, John James, shall now begin. John James in the County Court of Baltimore has sued James McCulloch in the County Court of Baltimore in the said state against the plaintiff in error, McCulloch, to recover certain penalties under the Act of Legislature of Maryland hereafter mentioned.
In my client's defense, the creation of the National Bank has been fully debated in Congress as means for conducting the nation's financial operations. Congress has declared this establishment to be necessary and proper. Thus, minute details of national programs could not be included in the original jurisdiction, the Constitution of the United States. Many legitimate powers of the federal government have been implied rather than directly stated in the Constitution, as the necessary and proper clause has pointed out. It does delegate the ability to tax and spend, and a bank is a proper and suitable instrument to assist operations of the government in the collection and distribution of revenue. Because federal laws have supremacy over states, Maryland had no power to interfere with the bank's operations by taxing it. The Maryland tax on the National Bank, therefore, was unconstitutional. Clearly, Mr. McCulloch was not responsible to pay the tax in which the state of Maryland has imposed.
Thank you very much, Mr. Webster. The court will view your opinion as we discuss the verdict. The court shall now call upon Joseph Hopkinson, representing the state of Maryland, claiming to sue James McCulloch.
Present, Your Honor.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You shall now state your argument on behalf of Maryland.
As is people with all authority to regulate business and tax, institutions within its own borders vested a sovereign state, Maryland. The regulation of banks was long accepted as a necessary means to prevent financial abuses. Since the federal government has created many statutes to regulate state banks, why is the state government not permitted to regulate the federal banks? Clearly, no authority to charter a federal bank was stated in the Constitution, and therefore the National Bank is unconstitutional.
Thank you very much for your opinions. The justices will now meet to discuss the verdict of the case. As for now, the court is adjourned.
This case presents a major challenge to the Constitution.
My question is, does the federal government hold sovereign power in the states?
No. I think it is clear to all of us that there are two main questions that we need to answer.
Does the Constitution allow the federal government to create a bank?
No.
Are the individual states allowed to create or tax the bank?
Do we all know where we stand in the vote? I reject Maryland's argument.
I shall second Marshall.
I agree with McCulloch's argument.
For McCulloch.
I agree with Duval. For McCulloch. I believe that Congress has the power to charter the bank, but Maryland is not permitted to tax.
I too agree with McCulloch.
Speaking on behalf of the court, Maryland's argument on a vote of 7-0 has been unanimously rejected. Let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, our Constitution. Chartering a national bank is an implied power over federal fiscal operations. Moreover, the individual states do not have the power to tax or ban the nation's bank. The Constitution and the laws made in pursuance thereof are supreme. They control the Constitution and laws of the respective states and cannot be controlled by them. The power to tax is the power to destroy. If the states do not have the power to destroy, then they do not have the power to tax. A state government could not interfere with a federal program that was exercising its constitutional powers in a particular state. Maryland's tax on the bank was interfering with the bank's constitutional powers, thus making it unconstitutional.
In the landmark Supreme Court case McCulloch v. Maryland, Chief Justice John Marshall handed down one of his most important decisions regarding the expansion of federal power. This case involved the power of Congress to charter a bank, which sparked the even broader issue of the division of powers between state and the federal government.
In my client's defense, the creation.
Tanya!
Shut up or leave! Okay, I'm sorry.
Hold on, it didn't start.
Oh, what is this?
Teddy, you should not waste the whatever.
You should go.
Yeah.
Never mind.
It start!
Wait, it didn't start. Hold on. That's go.
This case presents a major challenge to the Constitution.
It is a favorite government.
Well, they had Penn State back then, too.
No, it's not Penn State. It's
No, not like that.
Get out of
there. Go.
Does the federal government hold sovereign power of the United States? Find out when we return.
Does the federal Constitution allow the...
this argument.
Wait, it's too early.
That's nice.
I oppose,
Wait, hold on.
or I agree with Duval. Trans voted.